Good afternoon, everyone, and glad to talk and have a discussion regarding securities litigation, both in the United States and globally. We have a distinguished panel here with us. I myself, and I'm the less distinguished one, but I'm Jeremy Lieberman. I'm the managing partner of Pomerantz LLP. The firm is focused specifically on securities and shareholder litigation. I litigated with Roger, the Petrobras Securities Class Action, which settled for $3 billion, which is the 5th largest securities class action settlement in history. With me was my adversary, Roger Cooper, my adversary, now friend, Roger Cooper. He heads Cleary Gottlieb's securities litigation practice. He's internationally recognized as a leader in corporate litigation by ranking publications including Legal 500, Benchmark Litigation, and Chambers USA. Clients attest to Roger's reputation as a terrific strategist with a vast knowledge of his field of expertise and very talented, and I can attest to that as well. And we have here Peter Crudo, the Executive Vice President of Gilardi, and he handles all aspects of Gilardi's class action administration services. He directly oversees teams managing all complex administrations, and he's dealt with largest class action settlements in the world, including Enron for $7.2 billion, AOL Time Warner $2.2 billion, Household $1.57 billion. Do you deal with anything lower than a billion or no?
Too much.
He's our billion-dollar man, Mr. Crudo. So we've got a great panel here, a lot of experience, and I think we just dive right into things. So, I mean, as we heard, securities litigation throughout the world seems to be the largest source of recoveries in litigation. Right now, in 2022, there was $3.8 billion recovered in the United States alone. There's been over $110 billion recovered since 1995 when there was a change in the law in Congress, which changed how securities class actions are brought. So clearly it's a big business, as it were. It's an important industry. And it's important, I think, for how these cases are litigated, settled, and administered. It's an important economic and, I believe, social tool. And so delving into that, we're here in the UK, and clearly the focus is not just on US litigation, which I call domestic litigation, but really how these litigations impact the United States and abroad, and how the world is really getting very smaller, and as the world is shrinking, how that complicates US litigation. And so, Roger, I just want to start with you. How do you see, there was clearly the changes that were brought about by the Morrison decision, which perhaps you could describe, and how do you see how shareholder litigation has become more international in the past few years, and how that's made litigation easier, or it's made it more complicated?
Yeah. So let's go back to 2010, which is when the Supreme Court the U.S. Supreme Court issued its decision in the Morrison National Australia Bank case. And before that case, before that decision, there were a fair number of securities class actions brought in the U.S. Applying U.S. law, U.S. federal law, but to transactions that may have taken place outside the U.S., maybe the securities traded on a different exchange. And what Morrison did was limit the extraterritorial reach of the U.S. securities laws. And it said, look, those securities laws only cover claims where the securities are listed on a U.S. exchange, so listed on the New York Stock Exchange or NASDAQ, or the securities are traded in a domestic transaction. And as you can imagine, there's been a lot of litigation over what is a domestic transaction. It's created some mischief, it's created opportunities, created a lot of interesting issues. But that had the effect of closing off the number of claims that might have been, or cases that might have been brought in the US. And I think it's taken a little while, but one of the things that we've now seen is that as a result of that decision, there's an increasing amount of securities litigation being brought outside the US. There's increasing interest in bringing those cases that might have been brought within US courts. And since 2016, there's been approximately 60, on average, 60 securities fraud cases per year brought outside the US, which is nearly double the number that were brought in the previous 2 years. And I think that's just growing. Now, in some places like Canada or Israel, you have a set of securities laws that are very much like those in the US, and they provide a right of action, and there's cases being brought there, cases being brought in Australia. But we also see in the Netherlands cases that are brought that parallel US cases, but that might be brought under a bunch of different laws, provided there's a jurisdictional hook. And the case that Jeremy mentioned that he and I litigated, the Petrobras case, I think is a good example of this kind of globalization or internationalization. One thing that even with the Morrison decision we've seen, and Petrobras is a great example, is there's just more cases brought in the US against foreign issuers. And I think just the focus on being able to bring those cases so they are non-US companies, but they have ADRs listed in the US, or they have other securities that trade in the US, or you can make an argument that their securities trade in a domestic transaction. And Petrobras was the biggest ever. And before that, you didn't have a case that large. That's the largest settlement against a foreign issuer. But we also have other litigation in other countries running parallel. So there's been a parallel case in the Netherlands that is still going on. There was an interim decision issued this summer after merits hearings earlier this year. There's arbitrations brought in Brazil by investors who purchased Petrobras securities on the Bovespa or B3 now, down there. There's also litigation in Argentina brought by investors. So that phenomenon, I think, is fairly new, to see so many parallel cases brought by a global group of investors looking to recover in one jurisdiction or the other. And there's things to say about that. But I'm kind of curious, Jeremy, because you've been involved in bringing a number of cases, or last decade, involving foreign defendants or even foreign plaintiffs. And I'm interested in about how that's come about.
Yeah, I mean, so Morrison all of a sudden starts asking the question, where do you, make the transaction? Does it occur in the United States on a U.S. exchange? If it doesn't occur on a U.S. exchange, does it otherwise somehow occur in the United States? First of all, I mean, just as a first question, that question, if it's not a U.S. transaction, i.e., if it's not a stock exchange transaction, like a bond, let's say, the courts are all over the place as to what constitutes a domestic U.S. transaction. And there's case law. There's no consistent case law in the United States. If you're not purchasing your share, if you're purchasing, let's say, a bond, there simply is no consistent case law as to what is a domestic transaction. And so what happens is you're asking in the 21st century, where everything is done by computer, by internet, by however transactions are being done, and people are asking the question, where did this transaction occur? So let's say it's an OTC stock, again, not a domestic exchange. Let's say it's a bond, and you're asking these questions, and the answer is really, I mean, it's a 19th or 20th century question in a 21st century world, and you see the courts are just collapsing over themselves on it. They don't know how to answer this question. There's Absolute Activist, the Second Circuit case, which gives some guidelines, but every case says, well, you look at where's the money transfer, you look at where was the decision-making process made, and every case says, but that's not enough. But that's not enough. You have to look at everything, but there's no real checklist. And it's caused a lot of problems, and Petrobras has caused issues with the certification of a bond class. And I think personally, before I answer your question, Roger, I'm going to pose a question to you. Do you think this was a good ruling, Morrison? Do you think it was supposed to be a bright line rule, and has it made the world brighter, and has it made the line any more consistent and easy to apply, particularly for non-stock exchange securities? Yeah,
well, I think that the court thought that it was clarifying a rule, because the previous rule had been one that was very facts and circumstances, and so you never really kind of knew where you were going to end up. And I think the court did think it was imposing a bright line rule, and there's no question that what a domestic transaction is, even under the various tests, does not provide that bright line rule. And I think the Petrobras case, again, is interesting here, because it was a challenge to settle that case, in part because there was no way to get a clear understanding of who was inside and outside of that class, or at least the bond investor class, because we couldn't figure out how many of those transactions could be proven to be domestic or not. And we were able to take, because we also had a lot of opt-outs, so we took a lot of discovery of opt-out plaintiffs to ask them about lots of things in the case, including questions about where did you purchase this security? And we sought discovery from them, documentation, and we deposed people, and we saw just how difficult or impossible it actually was in many instances for the investors to demonstrate where the transaction took place. And in large part, it's because of the way these transactions occur, that where is an electronic transaction? Where does it happen? And you would have parties in different places in the world. You'd have a broker in another place, and it creates opportunities for certain arguments, like it did on class cert. We could talk about that in a little bit. But on figuring out the scope of the class, it was difficult, and we had to make estimates. And one of the things we wanted to be able to do as best as possible was get a global settlement, right? We wanted to release as many claims as possible in the US under US law. And what's happening, what's being litigated in the Netherlands are claims brought by investors that didn't give releases in the US. And so it's kind of everyone that did not trade in a domestic transaction. And I think there's still real questions of what are the contours of the class in the Netherlands still, just because it's not clear who is in and out even of the US settlement.
And so in answer to your question as to how does it impact our plaintiffs and plaintiffs' practice, really the Morrison rule was something that I think the defense bar all got behind. There was significant amicus briefs brought in support of making this bright line rule. They were saying, this was the Shangri-La of litigation. Everyone wanted to come to the United States, take advantage of the courts and cause such problems. And so the defense bar, I think, thought that by bringing Morrison, you're going to somehow limit exposure, and you're going to somehow, create real barriers to bringing cases, and therefore limit a corporation's liability. And what you see is it really did awaken a sleeping giant. You see that what happened is all of a sudden, non-US institutional investors started saying, well, when I purchase a share in the United States, I get a recovery. And then all of a sudden, if I purchase that very same company, a share outside the United States, I don't get a recovery. And that doesn't make a whole lot of sense. And so all of a sudden, the institutional investors started to wake up and say, well, what do I do? And so first of all, it spawned a lot of international cases. You have the Tesco case. You have the Volkswagen case in Germany. You have, the Olympia case in Japan. And there's a litany of cases. I'm missing several as I go through the list here. RBS in the UK. And so first of all, it spawned a whole lot of litigation, So it awakened that sleeping giant. But even more so, it actually brought European and UK investors to look at the US markets more and say, I wasn't really getting involved in the cases in the US, but you know what, now that I'm awakened to this issue and that I'm alert to it, I think I'm going to participate more in these cases. And that's exactly why our clients, University Superannuation Scheme, it's the largest pension fund in the UK, that's why they became a lead plaintiff. Absent Morrison, I don't think they became, I don't think they would have been interested in becoming a lead plaintiff. But all of a sudden, this Morrison issue they have to grapple with. They're not sure what to do. They're not sure what it means. And they say, you know what, let me throw my hat in the ring here. At least I'll have some influence as to how these litigations proceed. So I think that's one of the first effect of Morrison is that it's caused litigation to mushroom, which is really quite interesting. From our firm's perspective is we try whatever we can do. Still the best forum, despite the mushrooming going on in Europe and Brazil and other places, the best forum is still the United States. The United States have certain characteristics that still have not really been adopted outside the United States. One is there's no loser pays. The other is there's contingency fee litigation, and the other is that there's you can work on contingency. There's no loser phase, and there's no adverse costs. And so when you have all those ingredients, you all of a sudden have a very good system for litigating claims. A lot less risk to plaintiffs when you don't have a loser pay scenario. You don't have to have after the event insurance, third party insurance, and so all of a sudden it can be done very efficiently in the United States. So our first goal is really, even if it's a non-U.S. security, can we find a hook to bring the claim in the United States? And so we had the case against BP Everyone knows, dealing with the explosion in the Gulf of Mexico in 2010. And there were claims being brought in the United States for the ADSs, but the claims, which was brought as a class action, but there weren't claims being brought for the London-traded securities. And so our firm actually brought a claim in the United States under UK law, saying that the court could exercise supplemental jurisdiction over these claims because it was already hearing the class action under the US law, and the judge accepted it. And so we litigated a case in the Southern District of Texas applying UK law. And so that's our first go-to. In a similar case in the Parago action, it was a dual-listed security. You had shares traded on the New York Stock Exchange, and your shares also traded on the Tel Aviv Stock Exchange in Israel. And we said to the court, Tel Aviv actually had a provision that when it's a dual-listed security, they apply US law or the other, if it's Canadian law, if applicable. And we told the court, US law is applying anyhow. Why don't you just hear these claims as well alongside the US listed securities? And the court agreed. And there was a Tel Aviv certified class, and there's a class certified of the New York Stock Exchange listing. So that's our first goal, is really to see, can we somehow shoehorn these claims in, even if under non-US law, to bring them in the United States where you have a more favorable securities class action mechanism. If not, then we try to spawn, we advise our clients to get involved in cases in Europe and outside Europe, and that's really where we try to direct our clients. And so what I see as with Morrison, the effect of Morrison is that it's made things more complicated. The law is much less clear, actually, where they try to bring a bright line rule, and it's really, it just shows you the impact of, sometimes the Supreme Court, they sit in an ivory tower, and they think they're coming up with a rule, and then lo and behold, they realize that the rule they're promulgating has no easy, application in the actual real world. And maybe in 10, 15 years, they'll clarify the standards. Until then, there's a whole lot of confusion. But that's been our impact. But Peter, I want to know how it's impacted your practice.
Well, it's funny because it can create challenges for us as an administrator, just because we'll sometimes get transactions that are from other jurisdictions, right? Especially, I think, with Canadian cases, where there's overlap with an American case, we'll get a lot of claims that give us Canadian exchange and Canadian transactions. Airbus, which was mentioned earlier a couple times at different points last couple days, had an American settlement on the ADRs. It's obviously ongoing in the Netherlands, so it's another example of things moving forward in parallel directions. Interestingly, the SEC as a regulator is exempt from Morrison. So we've seen them take action that includes foreign exchanges, in some cases resulting in really voluminous volumes. So it's, I think it's playing out in different ways for us.
Yeah, it's increased fees, I hope. So
But it's an interesting question. So when you settle a case that includes claims, so foreign law claims because the court takes supplemental jurisdiction, and you have foreign law claims for securities traded on a foreign exchange, that can create real challenges, I think, for.
Yeah, and whenever someone has to decide whether or not something is a foreign traded claim or not, and that was really, it really just becomes quite difficult.
It adds some real inefficiency to the process. I mean, it's a lesser concern, granted. But
And Morrison, I believe, was a 9-0 ruling. I don't think there was any dissent. There were a few concurrences, but you had, the 9 of the smartest people in the world, arguably, coming up with what they thought was going to be a very simple and easy rule to apply, and yet just because they didn't have any practitioner's experience and didn't really, I don't think, understand the market, they didn't realize what a mess and confusion they were actually causing. So that's, that tells you,
Can I ask, Peter, what you have seen, so when you have a settlement and parties, the claimants have to come forward and demonstrate actually that they're part of the class, what have you seen as the requirements to show actually that you satisfy the domestic transaction, right? Some indicia that.
So we get all kinds of things. We get broker statements, we get custodial documentation, we get trading documents, we get declarations on occasion depending on the age of the data, right? One of the challenges I think we have, and I imagine you guys have at some levels, when you're dealing with an aged class period, people don't retain data like they used to. It used to be retain it, now it's get rid of it. So there's different forms, but those things have to be documented. And in the European cases, Fortis and Steinhoff, which we were lucky enough to do, I mean, those were really, really stringent requirements.
Great. So, I mean, as we're seeing, more of a, internationalization of securities litigation, one thing that you're all of a sudden seeing is a booming business of litigation funding. And so you see that in all over Europe and the UK, and we get, litigation funders will knock on our door, and particularly it's less relevant for a well-funded class action firm that could work on a contingency fee basis that doesn't need after the event insurance because there's no loser pays. But nevertheless, we do get pitches by these litigation funders. It's spawned really a whole new industry. Hedge funds are getting involved in these, involved in these fundings. Private equity firms are opening up funds. It's really become, big business. And Roger, how do you think that's impacting the litigation, marketplace?
Yeah, well, my first answer is I don't know. It's hard to say because we also don't, for the most part, don't have any disclosure requirements of funding relationships. So it's typically the case that if I am litigating against a plaintiff who's funded, I won't know. And actually sitting here, I don't know if I've ever actually litigated against a plaintiff that was funded. Now, I think there's just a lot more attention on funding issues in the US, and a lot more clients are starting to ask about it and starting to think about what it means. And so I think it's going to change a little bit. I think we're actually going to start pressing more to try to understand whether there is a funder behind the plaintiff, and to start doing more to try to use that as leverage in the litigation. And it strikes me in the securities class action, there can be issues already at the selection of the lead plaintiff stage. And I know of one case, I forget which case it is, but where one of the plaintiffs and law firms in their submission to be lead said, we're not taking funding. And that was supposed to be, something that the court would look at favorably. But in the Northern District of California, I think, and then New Jersey, there are some disclosure requirements for certain kinds of cases. I think New Jersey's everything, but that's the exception. But judges might not be as aware of this. And at the class search stage, I think there's questions also of trying to at least try to get discovery. If there's a funding relationship, it could go to the question of the adequacy of the plaintiff and the law firm if there's a funding relationship where there's some demonstrated control. Now, I understand that that's not generally the structure, but it's worthy of discovery, factual inquiry to see if there's some arguments to be developed, and clients are asking more about it. So I think it's going to become increasingly a part of the playbook by the defendants.
Yeah, I mean, we're seeing more. We're seeing questions about it more. So we have seen some smaller firms use litigation funding. There was a case in the Southern District of New York where actually, that was, we were co-lead counsel. Our firm did not use litigation funding. Our co-lead counsel did. Defendants had argued that made co-lead counsel inadequate because they weren't able to fund their own case. They, were subject to potential conflict of interest, et cetera, et cetera. Defendants could definitely make a lot of arguments about this. And so, yeah, it's definitely a risk. It's something that, even if I think the development of litigation funding in the world generally is a good thing, because what all it does is add more financing and more capital to these cases. The fact that you have, very, hedge funds, a lot of smart money investing in these claims and cases worldwide, I think is a very good thing. I think it actually, the more capital that flows to these cases but one way or the other increases the value of the cases overall, just a matter of economics. But, as far as firms using them, it's something that we've considered using it, and in cases where, non-class cases that might be very, very risky, we've taken a look and considered using it. We've actually never signed the paper and gone with litigation funding, but it's something that is more prevalent, and I think as more of these litigation funders come and knock on doors, the cash is attractive and seductive. So I think there will be firms that take the bite.
I could see actually in large cases where the damages are pretty substantial, large opt-outs being more comfortable, right? Because the return could be higher there for the funder.
And you're seeing litigation funders do that. They'll actually sometimes come to funds with large losses and say to them, we will buy the claim and assign it to us, and we'll pay you out now, and you can go ahead and prosecute. So we've seen that actually as well. Not from any of our clients, but it's something that's hit the industry. Peter, anything, has that somehow impacted your practice?
We don't typically see funders in the settlements we're doing domestically, but certainly in the 2 European cases, they were actively involved with the claimant groups. And I equate it a little bit to the PSLRA, right, which was designed to bring more institutional, more professional plaintiffs to American lawsuits when that was brought on. And I think, especially if you listen to the last couple of days of sessions, these guys take it very seriously. And so I think, our experience with them is they're smart, talented people that drove litigation, and obviously, both of these are €1.5 billion or dollar settlements, and had very good results. So, we didn't have a lot of direct interaction with them necessarily. Generally, it was post-settlement and obviously dealing with the active claimant groups, but certainly you saw the results.
And so, we see that the trend of securities class actions in the United States is, dipped a bit, but, maybe dipped a bit compared to a few years ago. It's kind of, had been stable for the past few years. And, Roger, what are you seeing? What types of claims what are the trends of claims you're seeing? There was something, people sometimes complain that there's, litigation that is, event-driven litigation, other forms of litigation that really don't belong in a securities fraud lawsuit, but somehow are being brought. And so what types of claims do you see, and are you seeing that type of trend of non-financial metric litigation seeping its way into the courts?
Yeah, well, look, for sure, right? That, I think, is the largest percentage of the securities litigation that I see on the defense side. And I think that is the story, right? Because if you go back to the first sort of 10 years or so after the PSLRA was adopted, or even a little bit further, right, the Enrons and WorldComs were really kind of financial-based cases, accounting, fraud, kind of that was what people thought of as the kind of core bread and butter cases. And then, maybe following the financial crisis, you had this emergence of what people called event-driven litigation, which focused more on qualitative kinds of statements that the company made. So the statements that they made about the strength of their controls or the ethical standards of their business and so on, and that those were being challenged as materially false or misleading. I think now people are talking about ESG as basically being more or less the same thing, because the G of ESG is goes to issues of corruption and governance, and it's all this stuff about controls and tone at the top and kinds of issues. I think Petrobras was in the G before we were talking about ESG. But when I talk with clients now about ESG risks, we're mostly thinking about climate, environmental issues. That is what is on everyone's mind, and there's a kind of expectation that we're going to see a lot more of that litigation. We haven't actually seen very much of it, and what we have seen has not been especially successful, in my view. There's a kind of greenwashing claims. There's a case that's gotten past the motion to dismiss against ExxonMobil related to how they had disclosed to investors the risks to the business and climate change issues. We represented Vale in the case that the SEC brought, which they proclaimed was the first ESG enforcement action they brought, where they argued that Vale had made misstatements in a sustainability report related to safety issues, and specifically around a dam and the engineering standards, and after following a dam collapse, and the environmental damage that caused. And there's a lot of litigation around that dam collapse and others. But the real focus is going to be, I think, look, companies have been making a lot of voluntary disclosure around climate, around their commitments in this area, net zero, and you have sustainability reports that are being put out voluntarily that have a lot of information in them. And so from my perspective, I think we're going to see like how well companies do under what they've chosen to disclose. But you do need some event, right? You need something that causes the stock to drop. And if you're going to go back then and look and say, oh, geez, you said you were doing these things, investors believed that over the last 3 years or so, you were committed and you had committees in place and you were doing various things, and it turns out really you weren't, right? So you need a whistleblower, you need like a short seller report, or you need a Wall Street Journal article, right, that comes out and says it turns out that this business or these parties in this industry really aren't living up to what they were stating were the standards that they were working under. But it's still tricky because a lot of the disclosure is aspirational, a lot of it's forward-looking, and there are good arguments that, or puffery, there are good arguments that it's not material and not something that you can challenge in a securities case.
Yeah,
but
I think you'll see that now the EU is coming up with, has new requirements for disclosures as to carbon footprints. The SEC is also requiring disclosures as to impacting environment as far as their businesses, and you actually are finding that companies are selling, and the problem that this poses for corporations is, for many companies, it's just impossible to quantify the impact on the environment. Maybe if you're an oil company, maybe you can, maybe, I'm not sure, but maybe you can. But when it comes to other businesses that are not necessarily thought of as those that are a threat to the environment, the SEC now is proposing rules that you would have to, every corporation should disclose the impact and quantify the impact on the environment. It's up to comment now in the SEC, but the EU has such rules. I think as those rules take effect and get promulgated, you'll see vendors. There's, for every rule, there's all of a sudden there's a business that comes out of that rule, and you'll see vendors that help you quantify your carbon footprints. And as those vendors sell those, they come out, it looks good, and it provides the company with some type of assurance or some type of crutch to use that we can rely on these metrics and on these quantifications. And what you'll realize is that one day you'll realize these quantifications aren't quite accurate and aren't really based in reality. And I think when you see that happening, as these rules take effect and as service providers are there and you realize that the service providers aren't really able to come up with a real practical way to quantify the carbon footprint, I think then you might see a lot of litigation regarding greenwashing and other issues. So that you might see as far as that goes. But yeah, I think until there's a definitive disclosure that needs to be made, you won't really see then material litigation revolved around that, except when you do see a few cases, as you mentioned, Exxon. There's also a claim against Wells Fargo, which was preliminarily dismissed, that Wells Fargo had certain practices with respect to hiring practices to make sure that they were hiring in a diverse manner, and they were actually coming up with fake interviews. They would already had their hire, but they wanted to show that for each management position that they were interviewing enough diverse candidates, and really it turned out to be these were in essence fake interviews just to check certain numbers and meet certain metrics, and the SEC commenced an investigation. So you might see the more a company discloses about their practices and the more definitive those disclosures are, is where you're going to find potentially litigation occurring. As far as event-driven litigation, and I agree it's kind of all fall under the umbrella of ESG. We had an interesting case against Arconic dealing with the Grenfell Tower, which everyone here is familiar with the tragedy there. Hundreds of lives were lost because of improper cladding that was put on the tower. And what does that have to do with Arconic? Arconic was the one that sold the cladding to the owners of the Grenfell Tower, and they were not supposed to sell. These claddings were not supposed to go above a certain, I think it was above 25 feet. It was considered to be, because they're highly flammable, and it was considered to be dangerous. And Arconic, it turned out, they were selling these claddings to the Grenfell Tower and to many other actually high-rise towers. And we were actually, when we brought the lawsuit in 2017, the case took a long time to resolve, and we brought the lawsuit, and actually, eminent Professor John Coffey wrote an article saying this is exactly what event-driven litigation is, and these are the exact types of claims that should not be brought. He thought these were, this bordered on the frivolous, this type of case. We litigated. The case was initially dismissed because there wasn't evidence that this was a widespread practice of Arconic of putting these claddings on high-risers when they should not have been. Evidence then came out as part of the criminal inquiry of the UK, and it came out that they had sold such claddings to hundreds of buildings, both in the UK and in the United States. we repled the claim. It actually got through a motion to dismiss. We just settled the claim for $74 million. And so it kind of shows you how shareholder litigation sometimes can take a more expansive view than we might initially think. You had John Coffey. There's no better expert or greater expert than him on securities law. In his view, this is not something that securities law contemplated, yet the judge disagreed and the company settled for $74 million. So you see what's happening is there is sometimes more, and we had, in the last panel, there's discussion of these permanent chemicals, and you see sometimes, courts, these are liabilities and exposures that mean a lot to investors, that really have an impact on the bottom line. Our firm represents the New York City pension funds and claim against AT&T with respect to the lead cables and the expose that occurred in the Wall Street Journal, that they had thousands and thousands of miles of lead cables that they own that have polluted the water, have been near school systems and near residential buildings, and chemical studies show that the lead exposure is significantly higher in those areas. And there have been commentaries by analysts that this could be a $60 billion exposure to AT&T, Verizon, and to others. And New York City brought a claim against AT&T, a securities claim, because there was actually, analysts had downgraded the stock as a result of those reports. So you see ESG and securities litigation, often entwined, do meet, despite some commentators to the contrary. And these things do impact. Anything that really impacts investors' choice and investors' investment-making decision, it is material to investors, and there is fair game for the securities laws, in our view. But Peter, you see any trends as far as cases?
So I think for us, we're at the tail end of the snowball rolling down the hill. So we're typically, settlements are occurring 3 to 5 years after the complaint was filed. So, by that time, typically the trend has moved on to something else. Personally, I think the data breaches and data controls and disclosures that are required related to them are going to be really interesting to watch play out over the next few years.
Yeah, I agree.
Yeah, I think the cyber issue, data breach issues are, that's an area that we're focused on from the defense side too. And it's become so routine for companies to get hit with a data breach, cyber attack, and kind of regardless of how strong your security systems are, and it just depends on what kind of business you are. But if you have a lot of customer data and you don't detect the intruder early on, you can have pretty substantial consequences. And we've heard a lot about the kinds of class actions that have been brought on behalf of customers, consumers related to their data. The cases that we see, securities cases, really depends on whether there's a substantial stock drop when the breach is announced, and that's not always the case, although it just kind of depends on a number of circumstances. But those cases have not been super successful. The Equifax case, which was one of the earliest, did settle for a pretty substantial amount, and I think people thought that there was something here. But the fact is, a lot of companies have pretty strong risk disclosures that make these cases fairly hard to pursue. The Meta case, the Cambridge Analytica case that the Ninth Circuit just reversed on, I think that's one example, though, where the court said, yeah, you can disclose the risks, but if you say that these things may occur, and it's well pled that they have already occurred at that time, and you haven't given that stronger disclosure, there's a claim here. And so that is a good example. But there's a lot of them that haven't been brought, somewhat to my surprise. And the other space, just for shareholder claims, are derivative claims against the boards, right, for failure to supervise lack of oversight when you have that kind of breach, and then you pay out a substantial settlement of the consumer class action. You have shareholders bringing claims against the boards in Delaware, and for a while it seemed like those might be another path that was going to be work for shareholders, but there's been the SolarWinds case and the Marriott case in Delaware that both said, unless you have really good facts that this board just really failed to supervise in this area, it's not going to be a Caremark claim and you can't proceed, and those have been dismissed. So I think there's a lot of challenges in bringing them, but it's an issue that corporate America, the global corporations are really facing.
Yeah, I think generally that's right, Roger. One thing you do see is, unfortunately, what happens is on the one hand, it's very hard to prevent a data breach. If the hackers want to get you, I think they're going to get you. On the other hand, what happens is that a lot of times corporations have a tendency to downplay the impact of a data breach because they want to reassure their customers, they want to put on a brave face, and so there'll be a data breach, and they'll say, okay, we've been breached. Either, and if they're fully transparent, there'll likely be no lawsuit, but a lot of times they'll say, well, there's very little impact, it's only affected certain servers and doesn't impact our operations, or client data has not been compromised, and then you learn months later that indeed the opposite is true. And so most cases, I think you're right, but you've got those exceptions. I see that the
or if you don't disclose right away.
If you don't disclose right away, which the SEC has a requirement to disclose.
Change now.
To disclose any data breach.
Yeah.
But I see we're running out of time, so if anyone has questions, please. Go ahead, yes.
Hi, yeah. As I mentioned in the introduction, a report earlier this year found that federal securities actions have declined over year on year on each of the last 4 years. So I just wondered if briefly you had observations on, given the trends that you've talked about, why that is.
I think I can speak for my firm is that after the financial crisis, there was some type of, let's say after those cases wound down, there was some type of experimentation in what are the new trends in the cases where, there was mention of event-driven litigation, what types of cases might succeed or might not succeed in the new era. And I think firms similar to mine or other competitors kind of matured in their view of what claims, could be brought and could not be brought in this post-financial crisis era. And I think so you found a big spike from 2012 to 2016. And as the years have gone by, it's kind of gone down and leveled off. And that reflects my firm's, filing practices. We've kind of, we got very active in some degree right after the financial crisis. Then we saw, well, these cases work, these cases don't, and we focused on what worked.
But I think if you look at core claims, the change is not that dramatic.
Yeah.
And there's also, if you look at like the Cornerstone data, one of the things that has changed dramatically are these federal cases brought in connection with like mergers, right? And there was a time period like 2017, 16, 17, 18, 19, when a lot of those, and they were just claims to do nothing other than to get a fee. And those are almost gone now, so that just affects the aggregate numbers. But if you look at the core filings.
Yeah, the core filings, I think there was some spike, and I think it's gone down and then leveled
off, I think, yeah.
No.
All right, thanks for sticking with us.
Thanks for sticking with us. Enjoy the drinks, and have a good night tonight.